Good afternoon, ladies and gentlemen, and welcome to the 2022 lecture series hosted by the Barbados Museum and Historical Society, the University of the West Indies Cave Hill Campus Department of History and Philosophy, and the Embassy of Argentina to Barbados. We appreciate your attendance at the first lecture of the series, and we're looking forward to engaging with you today. I am your chairperson, Dr. Alison Ramsey, of the History Department of the UWI St. Augustine campus. This afternoon's presenter, Professor Pedro Welch, will discuss the topic, tracking the historical development of a Barbados Constitution, identifying key moments in the historical record. In this presentation, he will track the history of constitutional development in Barbados, tracing the origins of some elements of constitutionalism back to the so-called Oyster Charter of 1652. He will also examine some of the constitutional development through the late 19th century and into the early 20th century. Professor Pedro L.V. Welch is a retired deputy principal of the University of the West Indies Cave Hill campus. In 2017, he was conferred with the title of Professor Emeritus by the UWI. He has also served previously as Dean of the Faculty of Humanities and Education and Professor of Social and Medical History in the Department of History at the UWI. He is the recipient of numerous awards, including a Commonwealth Scholarship in 1984, a Johns Hopkins Fellowship in 1992, and the December 2009 Principals Award of Excellence at the UWI. Professor Welch has written and co-authored several books and articles, including Red and Black Over White, Free-Colored Women in Pre-Emancipation Barbados, and Slave Society in the City, Bridgetown, Barbados, 1680 to 1834. He's also the editor of the Journal of the Barbados Museum and Historical Society. Of course, he has delivered several public lectures internationally, locally, and regionally. He is the current chairman of the Task Force on Reparations in Barbados as well. He's married to the former Joan Winter, and they have two children, Dr. Pedro Welch and Jem Welch, who is a teacher. He is an elder and organist of the Breath of Life Seventh-day Adventist Church. I'm sure that we will have plenty of questions and comments on this topic today, and I would kindly ask you, the members of the audience, to write your questions in the Q&A in Zoom or in the comment section on Facebook. And you can do so throughout the presentation, and we will address them at the end of Professor Welch's presentation. Thank you very much for that. Professor Welch, the floor is yours.
Thank you very much, Dr. Ramsey. It is certainly my pleasure to be with you this evening and to share some ideas on the whole question of the development of a Barbados Constitution. I've changed the title, tweaked it just a little bit. And so the lecture is now entitled Tracking the Historical Development of a Barbados Republican Constitution. And I have changed that issue of the key moments to selected key moments in the historical record. It's useful for us to note, even as I begin, that the etymology of the term republic, which is really a key term in this lecture series, has fairly ancient antecedents. Simply put, the term republic is derived from two Latin terms, res and publica, which in a basic translation means the public thing. But lest we assume that the Romans were the originators of the idea of a republic because we've used a Latin derivation, we also do well to note that the distinction belongs to the Greeks. I make these opening remarks because I have detected in the modern proponents of the Republican idea in the Caribbean a species of what I call ideological and intellectual arrogance. An ideological or intellectual arrogance that seeks to relegate to the dunghill of history all of the antecedents of our contemporary political systems on the basis that these antecedents are colonial. In short, what I'm saying is that very often we miss a key aspect of our historical investigation because sometimes we impose on the historical narrative certain ideological constraints. The fact that something is colonial does not in itself mean in an intellectual sense that everything that that might be defined as colonial is all bad. The things that are associated with the colonial experience are bad, but it does not mean that every last thing is. In that context, therefore, while acknowledging that the negative surviving elements of the colonial past still continue to hamper us in the Caribbean, it seems to me useful to note that we do ourselves a disservice if we fail to recognize that in that colonial past, some elements of the republicanism that we now espouse as being ultra-revolutionary existed. It is in that context that I propose, firstly, to take a journey into the political history of Great Britain, insofar as that history relates to the development of notions of representative government in the Caribbean, and more specifically in Barbados. Most historians of the Caribbean consider the ratification of the Articles of Agreement, also known as the Barbados Charter or the Oyster Charter, on January 17, 1652, as synonymous with the export of a developing English political tradition. In that context, it is useful also for us, if only to ensure that our audience is as fully informed as possible on the matter, to say something about the circumstances in Britain that led to the event of 1652 in Barbados. Remember, again, my argument is that the events of 1652 are a necessary precursor to what happens in 2021 when we become a republic. As many of us will be aware, the evolution of a British constitutional tradition will be traced back primarily to the 1215 signing of the so-termed Magna Carta or Magna Charter or Great Charter. That is itself preceded by what was referred to as the Charter of Liberties, promulgated in 1100 at the time of Henry I. Between 1215 and the early 17th century, the various clauses of Magna Carta were refined. However, for our purposes, we may note that in 1628, the so-called Petition of Right, building on the terms of Magna Carta and drafted by the celebrated English jurist Edward Coke, acting as chair of a parliamentary committee, set out certain rights of the English subject that the Crown was prohibited from restricting. This Petition of Right included restrictions on taxation without the sanction of Parliament. It reiterated the right of habeas corpus. And it also restricted the right of the Crown to billet troops on civilians by force. In short, what I'm saying is that long before we reach the modern age in which we now live, there were discussions taking place in Britain, and it is true that we're dealing with a Britain in which the masses are generally oppressed, and that there were the discussions taking place in Britain at many centuries ago, which had to do with what kinds of rights and privileges belong to the people, as distinct to those rights and privileges that belong to the Crown. In that context, therefore, with the whole question of the development of various rights and privileges, the struggle between Parliament and Crown arose and deepened and came to a head when Parliament insisted on its right to control the funding of the realm. In 1640, the British Parliament was ready to move in a decisive manner to assert its place in the governance of the realm. It passed a law that required it to be called into session every 3 years, with or without the king's sanction. Now, it's particularly important to bear that in mind, that this is Parliament dictating to the Crown that that is Parliament, has certain inalienable rights. Moreover, laws were passed which prohibited the king from raising any taxes without the express consent of Parliament. Thus, in 1642, matters reached a head when open war broke out between forces loyal to the crown and forces installed by Parliament. This lasted until 1646, when Charles the King was handed over by the Scots to Parliament and subsequently beheaded in 1649. It's at this point that we can pick up the thread of issues in Barbados that led to the signing of a charter, which we call the Oyster Charter, or the Barbados Charter. It was almost inevitable that colonists would take sides in the struggle between the Crown and Parliament. That's colonists in Barbados. During the years of instability in Britain, Barbadian planters and merchants had taken advantage of the uncertainties to expand trade with the Dutch. Now, with the conflict in England in full blast, and with Parliament in the ascendancy under the leadership of Oliver Cromwell, the royalists, that is those who support the crown in Barbados, led by a planter and member of the council, Humphrey Waldron, that's a quintessential Barbadian name, declared the island for Charles II. That is, they declared the island was a royalist island. Supporters of the parliamentary side had their estates sequestered and many were exiled from the island. When this news reached the parliamentary authorities in Britain, they proclaimed that the island was in rebellion and organized a naval force under the command of Sir George Askew to impose their authority over the island. They were also determined to deny the Dutch access to the island's trade. By the time that the parliamentary forces were being organized for the Barbados campaign, that is organized to impose rule over the Barbados situation, the royalists in Barbados were being led by a man called Lord Francis Willoughby of Parham. His story is an interesting one. Francis Willoughby was born around 1605 into a propertied English family, which had received a baronetcy in the late 16th century. During the conflict between Charles I and Parliament, he was at odds with the king over some of his religious and financial policies. In 1642, Lord Willoughby became involved in armed struggles, paradoxically, on the side of parliamentary forces. In fact, he became Speaker of the House of Lords in 1647. Later, Willoughby, a Presbyterian, fell up with Cromwell and his new model army and was imprisoned while along with other members of the aristocracy. And until after his release, he escaped to the Netherlands, joining the royalist cause. This is a very interesting character. Now, there's something that you're going to note in a moment. We have something on the screen. I'll get to that in a moment. As a result of Willoughby's alliance with the royalist cause, he received a commission from Charles II as an admiral, and was also appointed as governor of Barbados. Parliament in Britain sequestered his estates, and at that point, Willoughby sailed to the West Indies to begin his intrigues with the Barbadian royalists, eventually taking up his governorship in 1650. It was also during this period that he sent an expedition to Suriname, founding the capital city at Paramaribo. And there's a reason, and of course, Paramaribo is tied to the name Parham, Lord Willoughby of Parham. Willoughby proved himself to be an able commander in the Barbados situation, organizing the local forces. But in our survey, it is useful to identify elements of the political philosophy which Willoughby held, and which his royal supporters also held. And this is contained in a declaration recorded in an appendix to Schomburgk's History of Barbados. And we have it on the screen. We've extracted some of that declaration for our purposes. And this first part of the declaration reads, "Shall we be bound to the government and lordship of a parliament in which we have no representatives?" Note the issues here. Shall we be bound to the government and lordship of a parliament in which we have no representatives, or persons chosen by us for there to propound and consent to what may be needful to us? In truth, it goes on to say, the declaration goes on to say, this will be a slavery far exceeding all that the English nation have yet suffered. Interestingly enough, this reference to slavery here in this declaration, at the same time, when the question is raised whether they should be bound to the lordship of Parliament, which they had no representatives, this question of slavery is not really a reference to the slavery that we understand, the enslavement of hundreds of thousands, if not millions, of our African ancestors. The notions that Lord Willoughby is declaring and he and his fellows are declaring really have to do with their view that they had certain privileges. And those privileges were bound in the fact that they had a kind of what we may call representative government. We may call that part of they had what we call the old representative system. Let's go on a little further. The next slide should come up in a moment. And when that slide comes up, we'll be able to bring that also in this. In the next slide that should come, it went on to state, it's the same declaration. By the above said act, all outlandish nations are forbidden to hold any correspondency or traffic with the inhabitants of this island. But we declare that we shall never be so unthankful to the Netherlanders for their former help and assistance as to deny or forbid them or any nation the freedom of our harbors and the protection of our laws, by which they may continue, if they please, all freedom of commerce in traffic with us. In the last clause of the declaration, Willoughby and his supporters state, we cannot think that there be any among us who are so simple and so unworthily minded that they would not rather choose a noble death than forsake their own liberties and privileges. The point I'm making here to us is that as we move towards the installation of what we call the Barbados Charter, we have persons who are pretty clear in their own minds that there were certain privileges, certain liberties that they held, and that these liberties that they held, these privileges that they held, were not negotiable. The principles that they are identifying here are principles that we will discover and rediscover as we trace Barbadian history onwards. In any case, with the arrival of the English forces off Barbados, a blockade of the island ensued. For several weeks, Willoughby's forces held out. However, eventually, some of the Barbadian supports went over to the enemy, and it became clear that the royalists would eventually have to give way and seek accommodation. I'm just going to ask or folk who are dealing with the system. Yes, thank you very much. Can you move the screen, move the slide a bit? Next slide after that one, please. We've gone past that one. Yes, next one, please. Next slide. Let's hold it there. Thank you very much. So that in this particular case now, I said some of the Barbadian royalists went over to the enemy side. Willoughby named some people as emissaries who he recognized would be the ones who negotiate with the parliamentary forces. And the emissaries were people like a man called Richard Pearse, Charles Pym, Thomas Ellis, and William Byam, all of whom had held commissions in local militia. The acknowledgement of the final acceptance of terms and the identification of the place where the two parties would sign off on the agreement between them were captured in the calendar of state papers. And it makes the point that the agreement was signed on board a ship called the Rainbow. This is a British naval ship in Oyster Bay at a place called the Mermaid Tavern. What is particularly important for us to note that after an initial agreement was signed, we find that the invading forces, that is the Cromwellian forces, were quite willing to go easy on the Barbadian royalists. As a result of their discussions, they eventually signed what we call the Articles of agreement, the so-called Barbados Charter. And in that Barbados Charter, we're going to see that there are some things that continue to form the bedrock of a Barbadian parliamentary tradition, of a Barbadian parliamentary system for centuries onward. The Articles of Agreement are testimony to the absolute leadership of Willoughby and his representatives. Although we cannot omit some consideration that class solidarity between Sir George Askew and his representatives and Willoughby's group might have played some part in the leniency of the agreements. Again, some references to the documents that emanate from this period, as well as selected portions of the article which we have before us, will help to assist us in understanding the scope of the settlement. On January 6, 1652, Askew sent a letter to Willoughby, and he refers to 12 articles identified as proposals from the commissioners appointed by authority of Parliament for the reduction of Barbados. And it is a preamble here, and after the preamble, we then come face to face with the Articles of Agreement. And these are some of the terms of the article that you have. One, that liberty of conscience in matters of religion be allowed to all. Secondly, that no taxes, customs, imports, and I assume that in the document in which I got this, that there might be imports, loans or excise shall be laid nor levy made on any of the inhabitants of this island without, and I wish all of us to note the particular terms that end that second clause. None of these things, no imports, no taxes, no customs, no imports, no loan or excise shall be laid nor levy made on any of the inhabitants of the island without their consent in a general assembly. It is terms such as these that underlay the development of a tradition of parliamentary independence in Barbados, and that we can track right through from that time right until the promulgation, the proclamation of a Barbados Republic in 2021. The next clause, clause 5, I'm going to ask again that if you can shift the screen here, clause 5, that all suits between party and party and criminal and common pleas be determined here, that is in Barbados, and none be compelled to go into England to assert or defend their titles to any estate, and notice again, without the consent of the General Assembly. The next slide, please. The next one. We'll look at the next one as well. Okay, sorry, I'm sorry. There's some of those clauses that are not here in the screen, but I will share some with you. It goes on to make the point that Lord Willoughby, this is clause 16, of Parham shall have all his lands or estate, whatsoever personal, real and personal, in England or wherever, restored to him, and that he should enjoy all of his property without disturbance. These articles of agreement are very generous indeed, and if the various clauses were honored, would have represented a major triumph of reason on both sides. A report of August 1652 informs us that Parliament had ordered that the Council of State should make a speedy report, and Parliament here means Parliament in Britain, touching the articles made upon the surrender of Barbados, which articles were approved and confirmed by Parliament on the 18th of August following. However, as it will turn out, it is not so easy to forget the acrimony that had existed previously. Willoughby was allowed to leave the island peaceably. Indeed, after installing a Daniel Searle as governor, Askew left in March for England himself. And soon after his departure, Searle wrote Lord Willoughby, having been ordered to quit the island, left on the 27th of March last of Suriname, but returned yesterday for provisions which were granted. He had been ordered that day to withdraw and goes to Antigua and so for England. Willoughby eventually arrived in England under the protection of the Articles of Agreement. However, for several of his co-insurrectionists, every effort was made to prevent them from benefiting under the agreement. In the end, what we see on the screen is an act of 1652, March the 4th, to wit that in the assembly, certain persons who are mentioned here, Humphrey Waldron, Edward Waldron, etc., were banished from the island for 1 year by an act and are prohibited from returning without license from Parliament or the Council of State under penalty of being deemed enemies to the peace of the island and proceeded against accordingly. Eventually, Willoughby's intrigues on behalf of his royal benefactors led to his escape from England. And at this time, his estates in England were seized and they were not returned until what we call the Restoration. At this point, we will return to a consideration of the place of the Articles within a broader debate on the question of the rights of Englishmen outside of the realm. The situation in Barbados did not mark the first time that the position of English subjects living outside of the realm was discussed. As early as 1608, there was a case of Robert Calvin, which sought to determine whether, following the assumption of the English crown by James VI of Scotland, persons born in Scotland could be considered subjects of the English crown and therefore entitled to the protection of English law. In considering Calvin's case, Paul J. Price, writing in the Yale Journal of Law and Humanities, notes that Sir Edward Coke, one of the judges deciding Calvin's case, has said that the court's determination was required by the divine law of nature, quote unquote, which is indeed the eternal law of the Creator, quote unquote, and part of the law of England. The case involved the confiscation of 2 estates that had been left in England to Robert Calvin, a miner who was born in Scotland in 1603. His guardians sued for the return of the property on the basis that as a subject of the king, he was entitled to hold property in England. On the other hand, the defendants sought to have the case dismissed on the basis that Calvin was born in Scotland and thus, in their view, not entitled to hold freehold property in England. And thus, in the end, 12 of 14 justices who were assembled to hear the case determined that those who were born in Scotland after James's accession to the crown and who are referred to as the post-nati were entitled to possess property in England. Price, in citing Coke's report on the case, can we go to the next slide, please? I think that may well be right. Yes, makes the point. Everyone born within the dominion of the King of England, whether here or in his colonies or dependencies, being under the protection of, therefore, according to our common law, owes allegiance to the king and is subject to all the duties and entitled to enjoy all the rights and liberties of an Englishman. Even before the 1608 case, as Price informs us, there was a 1607 publication by one John Cowell that found that, and I think that may well be also the next slide that should follow. Can you just shift that to the next slide, please? No, let's keep that there for the moment. I'll read it from what I have here. This publication by John Cowell in 1607 reads, "A man born out of the land, so it be within the limits of the king's obedience beyond the seas, or of English parents out of the king's obedience. So the parents at the time of birth be of the king's allegiance, is no alien in account, but a subject to the king." The reason why I've included all of this is because what we are looking at in the case of the Barbados Charter is an assertion of the rights of Englishmen living overseas. And a lot of that is tied up to these cases that I'm referring to. And we don't have time this evening to really get into a full discussion of all these legal precedents. So in a final analysis, At a time when Englishmen were journeying not just to Ireland, Scotland and Wales, but to the New World, the rights of Englishmen overseas were being enshrined in a common law, such that colonists overseas could claim legal precedence in their quest to establish some autonomy in the new lands that they sought to own. The extent to which legal borrowing in the establishment of the English New World colonies, the legal borrowing in the establishment of these colonies is captured in Bradley Nicholson's excellent survey, Legal Borrowings and the Origins of Slave Law in the British colonies, or the English New World colonies. This is in the American Journal of Legal History, volume 38, number 1, 1994, pages 38 to 54. With respect to the slave laws, the conventional wisdom is that harsh slave laws that were enacted through the English Americas and the English West Indian colonies were almost entirely a colonial production, without old world precedents. However, in following the lead of legal historian Alan Watson, Nicholson states, and I'm reading on the screen now, I argue that early American slave law was based on English legal traditions, mostly outside the common law, rather than created in the colonies out of whole cloth. Virginia and Barbados developed slave codes during the 17th and early 18th centuries. The point, therefore, that we are making here is that we mustn't assume that the laws that are that we see, or the articles that we see in the Barbados Charter, that these are something that suddenly arose in Barbados alone, but they're part of a discussion that has been going on in Britain for quite a long time. As in the case of the slave codes, the elements of the framing of the charter, the Barbados Charter, were built on legal precedents that were already well known in the mother country. Even where we will see evidence of borrowing by other colonies from the Barbados experience, we must also be careful to acknowledge that the Barbados experience was also heavily influenced by the world from which the colonists had come. That is not to say, however, that what emerged in the various colonies was not heavily influenced by the peculiar local conditions resident in the New World, and that there was not an element of innovation in the case of Barbados and the case of codes that were developed elsewhere in the English colonial world. Again, we might note with some interest the important contribution made to a discussion on the legal and constitutional history of the British Empire offered by Daniel Hulse-Bosch. In a few minutes, that should come on the screen as well. I'm just trying to synchronize between what I have here and what comes. So can you go to the next slide, please? Yes. No, you can go past that. Next slide after that. Yes. I'm referring to the work of Daniel Hulse-Bosch, who's looking at the whole question of the development of law. And he observed that Edward Coke's commentaries indicate that elements of the common law culture of England, more specifically the common law as it related to tenure in real property and to the right to representative government, all these represent inheritances that were migrated from England or Britain into the colonies. So he states, for constitutional questions, at least that's on the screen, it is helpful to view English legal culture as a literary canon and a set of practices which, with overseas actors, drawing creatively upon the canon as they perform the rituals of law against a new dynamic backdrop. Let's look a little further at the next slide. This should come also from Hulse-Bosch. He says, Irish and West Indian colonists were among the earliest innovators upon Coke's script of ancient liberties. Their arguments circulated through the British Atlantic world, including North America, where colonists embraced these ideas tightly in the 1680s and developed them insistently 2 generations later. Incidentally, before we move off from this particular extract, I wish to note here that as we look outside of Barbados and we look at the development later, past the 1650s into the 18th century, and in particular, looking at the American Revolution. When we look at the American Revolution and the installation of the American Republic, we are also witnessing an assertion of rights and privileges that in fact were inherited from earlier legal precedents in Britain. Many persons might not be familiar with the work of Jack P. Green. Jack P. Green is a scholar writing primarily in the early 1960s and then onwards. And he wrote a paper on the role of the lower houses of assembly in American history, in American political history. And he has identified the fact that a lot of the ideas that went into the proclamation of the American nation, a lot of the ideas that went into the American Revolution were in fact ideas that were being tested at the level of the local assemblies. So like by the Barbadian cousins, many of the arguments that are being put forth by the American revolutionaries had to do with the whole question of identifying and asserting rights and privileges that belong to these people in contest with the crown. Let's go to the next slide, please. Let me pick that up so I can fit in right. Now, let's move from the American situation and see what's happening there. Liam O'Mellen, who is another researcher who's looked at the whole question of constitutional development in the New World and in Barbados in particular as well, he writes, from 1648 to 1651, Barbadians used their assembly to define the relation between the corporate settlement and the mother country. Whereas the assembly had initially worked out the relation between the settlers and the proprietors, at the end of the 1640s, it embarked on a legal project of far greater magnitude. In short, what the point that Liam O'Mellen is making, as in fact Paulson Bosch was making earlier, is that when we look at the discussions that are taking place in the Caribbean and in North America regarding the extent of the rights and privileges of the people compared to the realm of the crown or the government, and when we look at all of that, what we are actually noting and seeing is your working, as I said, of a series of discussions that date right back and in a very connected line right to Magna Carta and onwards. So here we are. We notice, therefore, when we come back to the whole question of what happened in the Articles of Confederation of Agreement, the Oyster Charter, that what the colonists were already claiming was that Parliament was sovereign. They weren't saying that in those exact words, but they were already declaring that they were sovereign, that they had certain rights and privileges that could not be challenged. Next slide, please. Let's go to the next slide. Let's go to the next slide, right. Again, looking at what O'Mellen is saying concerning what's happening in Barbados, it said that is the Barbados Assembly, explained consistent with the requirements of Calvin's case that I referred to earlier, that is connected with England via the king, as if it were a federated dominion. It owed no allegiance to an unconstitutional body in which it was not represented. Oh, these are bold, this is a bold assertion, a very bold assertion. In other words, whether the colonists understood it or not, their arguments went far beyond a simple assertion of their independence. Their arguments really went like the core of a later constitutional development to take place in Barbados and throughout the other Caribbean colonies. To continue, therefore, one, which the West has cited by Hudson-Botts, declared, the common law of England is the common law of the plantations, and all statutes in affirmance of the common law passed in England antecedent to the settlement of a colony are enforced there unless there's some private act to the contrary. As a further development of the themes that we've been identifying, the Privy Council in England confirmed in 1722 that when Englishmen settled overseas, they carried with them English law as their birthright. So that when the Earl of Carlisle, the first settler of Barbados, arrives in Barbados, the settlers refused to countenance his governorship until they had acceded to their demand that they were the ones to determine his legitimacy. And the governor, Charles Wolverstone, installed by the Earl of Carlisle, was only permitted to take up his office in the island when the settlers had summoned a general assembly and confirmed Carlisle as their lord and Wolverstone as his governor. So as Mellon, who we spoke to a little earlier about, tells us, from the very start of settlement, late in the 1620s, the colonists asserted that they were entitled to the rights of Englishmen from the first, and they insisted that subject to the king and only the king. With the signing of the Articles of Agreement then, the colonists were in a better position to assert the case. It is true that in the months after the initial signing, while they were waiting for the ratification by Parliament in England, they could not be certain that the victors would confirm their position. However, it was seen that the Barbadian colonists did consider their case irreversible. It is in that context that the Calendar of State Papers in 1652, we got a letter from a man called John Bayes. Can you move up the screen a little further, please? Let me see if we can pick this one up. By John Bayes. There's a yes, no, move on past that because there's another one, go past that. Yes. And this is a complaint by a John Bayes, and this is what is said here. And it's a letter from John Bayes, Treasurer of Barbados, to the Council of State in England. And this is what he complains. He complains of the choice of this Parliamentary Assembly made during Ayscu's government, the outing of Lord Willoughby, the Waldrons, Ellis, Shelley, Bynum, and other malignants was of great future security to this place. But they fell to making laws and now will not be removed without some clashing. Next slide, please. Next slide. Next slide, that this complaint continues. He believes the greatest part of the assembly to be all desperate malignants. The privilege afforded to those bringing actions at common law of appeal to the governor and council has been taken away by a late act of assembly. Addresses to the island, to the governor are thus taken off. They call themselves the representatives of the island, but believes if suffered, they will in time become the sole power. This is a man called John Bayes, the treasurer of the island, who is commenting on what is happening in Barbados, subsequent to the signing of the Articles of Oyster's, the Oyster's Articles, Oyster Charter. And what he is picking up is that he is actually foreseeing a struggle that is going to become wider and wider until eventually, as we move from this early period into the 1870s, we find that the Barbados Assembly has become so self-confident of its power that it, in fact, eventually will challenge the very governor himself. what I'm arguing here, therefore, all of this discussion we've been having thus far is just simply to establish that long before we get to the Proclamation of Republic in Barbados in 2021, long before we get there, we are looking at the development of a polity, the development of a political system, a parliamentary system in Barbados, which is establishing its rights and privileges against those rights and privileges that belong to the Crown. Next slide, please. Next slide. As an aside, let us note, let's go back to that, please. We'll say just before, yes. Just let me go to this point here. I've been speaking about the whole question of the origin of a Barbadian political tradition, a tradition of parliamentary independence in the period between the signing of the Articles and later. But this is not intended in any way to suggest that we're talking about some altruistic system which respected human rights. Africans, as we are absolutely clear, are excluded from any consideration. And we find that the 1721, for example, there's a law that is passed which says no person whatsoever, this is on the screen, shall be admitted as a freeholder or an evidence in any case whatsoever, whose original extraction shall be proved to have been from a Negro, excepting only the trial of Negroes and other slaves. So the answer is clear. The Articles of Confederation established an independence and a jurisdiction for white enslavers. But because it established that jurisdiction and that control in these persons, does not mean that we should simply dismiss all that had happened at the earlier period as being irrelevant to our proclamation of a republic. The principles of parliamentary freedom, the principles of liberty of conscience, etc. All of these issues which are later going to be applied when we look at the whole question of a republic. These things are there. Yes, they're there in the Articles of the Barbados Charter. They're there in English, Old English precedents. Yes, it is true that Africans are excluded, but there are principles that are laid down which we will take up later in 1943 when we have the accession of the franchise in Barbados, and when people of African descent come into Parliament in their own right and begin to control the island. That would not have been possible if the parliamentary traditions had not been laid down as far back as the Oyster Charter. Okay, next slide, please. Next slide. I'm just coming back to Willoughby. I want to show this one just in here. Willoughby, who we encountered a long time ago when it began, came back to Barbados, became governor in the 1660s, etc. And he's writing to the king, and listen to what is happening here. He's ashamed to think how unprofitable a servant he has been. But the last fleet he sent home for trial, one farmer with articles against him, a very dangerous fellow. And notice how he describes this farmer. A great Magna Carta man, that Magna Carta, and a petition of right maker. The first that started up that kind of language here, which took so if the people that Willoughby did not think it safe to let him remain in the island. Next slide after that, please. The next slide. And this just is talking about this farmer, where he set all the people into flame and brought them to think that they were not governed by His Majesty's commission or anything but their own laws or rather their own wills, for they were beginning to dance after the long Parliament's pipe, styling it the best of parliaments, which is the doctrine of this John Cade. Now, I'm saying this to you, I brought this in here because even though Willoughby was part of the rebellion against the Cromwell's groups. Even though he was part of the signing of these articles of the Barbados Charter, the fact remains that he himself also recognized that there were elements that were released in the Barbados Charter which were inimical to the fortunes of the crown. So it's a bit of a paradox. Next slide, please. Next slide. Next slide, please. Yes. Following the 1600s, the next key event is this whole question of what is called the Stamp Act. What happens in the case of a Stamp Act? The British government tried to impose stamp duties in order to fund the cost of putting on a rebellion, a series of rebellions through the colonies. They also passed a stamp or imposed stamp duties in North America. And part of the reason for the American Revolution is also a response by American colonists to the imposition of the Stamp Act. It required, the Stamp Act required printing materials, including newspapers, legal documents, and the like, to produce on paper that was embossed with a revenue stamp. As Andrew O'Shaughnessy comments, there was opposition throughout the colonies. Citing Henry Duke, the Solicitor General of Barbados at the time the act was passed, it is said that the whole island has opposed the Stamp Act. It was an invasion, they said, of the constitutional right, quote unquote, the constitutional rights of English subjects. And further, this is what they were saying, rather what O'Shaughnessy says about in describing the condition then, says in addition to appealing to the British Constitution, if such a document even existed, the Barbados Assembly, this is the 1760s, also cited the authority of the island's charter. So there's no doubt that 100 years after the signing of the Oyster Charter, that the Barbados House of Assembly, Barbados Assembly, is clear in its conception that the Barbados Charter offered them some authority. Of course, later on, the Barbadians themselves make a lot of concessions to the British Crown with respect to the Stamp Act. They seem to move into a conciliatory mode. But the important point is this, is that as far as the Barbados House Assembly was concerned, their rights and privileges were enshrined in an agreement made between their representatives, or the early representatives, and representatives of British government. Next slide, please. Next slide. We'll soon come into the last lap. Let's go to the next slide, please. I'm just asking, yes. We come now beyond the 1760s. We've gone rapidly from the 1650s and then into that key moment of the Stamp Act of the 1760s and how the Barbadian Assembly viewed its rights and privileges. And now we come to what I call the Confederation Issue. We come to the 18, as far down now as the 1870s. By the 1870s, you have a series of discussions taking place in the British Parliament, in the British colonial authorities, over what is to be done with the houses of assembly in the Caribbean. We have passed abolition of enslavement in 1838, the end of the apprenticeship system later, and we've come into a period where the British government is under some pressure to ameliorate the conditions of the formerly enslaved. And as part of their process in which they sought to reform the Houses of Assembly, the various assemblies in the Caribbean, the British authorities unleash what we call some political forces that were designed to wrest control from the House Assembly and increase the what we call the authority of the local governments. Well, what happens at that time is that in the 1860s, in the case of Jamaica, you have the so-called Morant Bay Rebellion. And as a result of the Morant Bay Rebellion, the English government, the British government, was able to put in place Crown Colony government in Jamaica and to effect some political control, greater political control over the political situation in the country, in Jamaica. This is also true of several other territories within the Caribbean. There were some newer territories that have come into control of the British government. And these newer territories, Crown Colonies, did not require any adjustments because the British government was pretty much in control. In the Leeward Islands, there were also some changes that took place that that reduced some of the power of the assemblies and enhanced the power of the governors. But it did not happen in Barbados. That's the point I'm making here. One governor, Governor Rawson, comes to Barbados, I think in 1875, going into 1876. And he alludes to what's happening. And I read under the title here, the Confederation Issue. The knowledge that the Duke of Buckingham had proposed a change here, similar to that which had been initiated in the Leeward Islands, and the belief that I had been appointed to carry out the measures had aroused a feeling of suspicion and jealousy in those islands whose inhabitants were not then and probably are not now prepared to surrender their constitution. I want you to note those words carefully. They're not prepared to surrender their constitution. In short, what Governor Rawson is pointing out here is that the Barbadian Assembly was so absolutely certain of its rights and privileges, and I'm using rights and privileges there in the contextual sense, that they were going to fight like the devil to ensure that even the British government did not succeed in imposing changes on Barbados. And what they harken back to is not just British tradition, legal tradition, but they're harking back to the rights that they felt that had been devolved to them under the Charter of Barbados, the Oyster Charter. Next slide, please. Now, Rawson is continuing his discussion, his description of what happened in Barbados, said, I had also inherited a special difficulty from my predecessor in the conflict between governor and council and assembly, which increased the indisposition of the popular body, that is the assembly, in this island to weaken the hold over the governor and the executive. Now, one of the things that you recognize is that given the realities that are stated by Governor Rawson, it is not surprising that his successor, a man called John Pope Hennessy, could be seen as entering the veritable lion's den when he arrived in Barbados in 1876. On his arrival, he immediately ran into a stone wall of opposition. In addition to opposition to the plan for federation, because one of the plans that the British government was trying to push was to federate Barbados with the Leeward Islands. And if they federated Barbados with the Leeward Islands, the idea would be that you would dilute some of the power of the Barbados Assembly. So Hennessy comes in here, and he promotes this plan of federation. But the Barbados House of Assembly decided that it was not going to move in that direction. The colonial office had also determined to use an imperial weapon to achieve its objective of parliamentary reform, namely the instrument of letters patent. Letters patent refer to legal instruments in the form of published directives issued by the Crown. The term itself derives from the Latin literae patentis. Once issued by the Crown, these had the force of law. In the Barbados case, it was intended to force reform in the system of government such that an executive council will be created that will be separate from the upper chamber of the House. Once Hennessy introduced a proposal, the Assembly quickly perceived that this was just another plan for their obsolescence. And the response of the Assembly was to enlist the support of their allies outside the House. And they had a big public campaign, which also had the effect of arousing the curiosity of the masses. And the turmoil in Barbados led to what we call the Confederation Rights, because the masses perceived that the Barbados Assembly and the planters in general were trying to thwart the governor's plan for improvements in the conditions of the island. Now, some of that was probably a misinterpretation by the masses, but in the end, the plantocratic elements in Barbados used the opportunity to launch a broadside against Governor Pope Hennessy, and he was accused of instigating riots among the workers. And eventually, the response of the British authorities was to transfer Pope Hennessy to Hong Kong. And the new governor, Governor Strachan, delayed issuing writs of election for 1 year. He delayed that for that 1 year. But in the end, what happened was this, that new governor also found that he had no choice but to confirm the Assembly of Barbados in its privileged position. What are some of the factors that might have contributed to the retention of parliamentary independence then and privilege in Barbados? Firstly, the almost total control over land resources placed the planter class in a position of strength over the working class. Also, the relative absence of a peasantry meant that the Barbadian elite wasn't faced with a substantial growth of a small landowning class who, as in Jamaica, could acquire enough land to challenge the control of the planters over access to the franchise. In fact, in Jamaica, by the 1850s, several smallholders in Jamaica in various parishes were beginning to contest and win seats in the vestry elections. But things in Barbados were different. Just as the visitor W.G. Sibel tells us in his book, The Ordeal of Free Labor, the Barbadian never had the option of working for low wages or starvation. Additionally, Barbados had proportionately the largest resident proprietary class in the Anglophone Caribbean, and many of these were in fact well educated. But notwithstanding the general stability of the Barbadian social and economic scene under the control of the planters, the colonial office did really try their best to make some changes in Barbados. But in the end, based on the precedents laid down in the charter, the Barbados Charter, and other legal arguments which could be traced back over the centuries. Based on those arguments, the Barbadian Assembly continued its path, and nothing changed in Barbados until the 1940s, when the Representation of the People Act for the first time, the masses begin to have a greater access to the political system. Let me summarize a couple of things here for us. We have a parliamentary system that develops in Barbados. The parliamentary system in Barbados, as we find in the United States of America, clearly argued that persons should not be, as it were, hamstrung by persons who do not represent them. In short, the arguments that were put in place in Barbados and elsewhere was that there were certain rights and privileges dating back to Magna Carta, and the colonists who entered the assemblies could look back to those principles, those ancient systems, to argue that there were certain rights and privileges that they had that could not be challenged. That's where the thing starts. The Barbados Charter then therefore begins to put in place an understanding of parliamentary independence, which continues right through until the 1940s. In that case, most of the what they call the reforms that took place in Barbados in the 1940s really have to do with the fact that once Parliament had managed to put in place an Afro-Barbadian majority, that majority could use all of the rights and privileges enshrined in their parliamentary positions to effect some changes in what was taking place here. That happened in the 1940s. As we move past the 1940s and we move towards the period of independence, again, the issue of independence, notwithstanding the need to go to Britain and to get what we call certain concessions from the colonial office, the fact remains it is the whole of the ruling DLP over the Parliament of Barbados that eventually permits the DLP government to push the island towards independence. There was no referendum in Barbados. There was no special right to independence which was derived from the people. The move towards independence really is a move which is engineered in the bowels of Parliament itself. Although this is a Parliament in which party politics and party systems predominate. Moving past that period of independence into 2021, when the Republic is proclaimed in Barbados, we may note there's no military struggle for independence. There's no military struggle to proclaim the Republic. All that it takes is certain actions of Parliament. And those actions in Parliament receive special legitimacy based on a tradition that was inherited from an even earlier parliamentary structure in this island. The Parliament of 2021 is, largely speaking, the Parliament represents the majority of the people in Barbados, the Afro-Barbadian majority, largely. And true, we cannot compare them in terms of their race class identities to those persons who were in charge in the 1650s. But the parliamentary legacy that they had inherited from that earlier beginning in 1652, that parliamentary legacy is a legacy that provides the legitimacy that was required to proclaim Barbados as a republic. The late Simeon McIntosh, professor of constitutional law, made it clear that as far as he was concerned, Barbados was already a republic. And he did not say that Barbados was already a republic in the context of some proclamation. He simply meant that the sovereignty of Parliament in Barbados meant that it was Parliament that controlled things, not the Crown. And in that context, our republic had begun, and we trace its background back to 1652. I thank you, ladies and gentlemen. Thank you.
Thank you very much, Professor Welch. The floor is open for any questions and any comments. Please use the question and answer in the Zoom, and you can also provide any comments or questions through the museum's Facebook page. Okay, well, while we wait on a question or comment, Professor Welch, I would want to ask you, how important do you think is this linkage between the Oyster Charter to 2021's events in terms of the various constitutional or legislative changes that took place within our parliament and so forth? What is the connection to you?
Okay, let me step back a bit, because clearly in a lecture of this kind, there's a lot of ends, a lot of things that it take you several lectures really to pull a lot of the things together. The simple point is this: Englishmen arrived in Barbados, and my discussion is not denying the impact of enslavement and all that took place. That is there, but Englishmen arrived in Barbados. What they did is that they brought with them a certain historical legacy. That legacy really dates back, as I pointed out in the beginning of the lecture, to the liberties that were derived out of the struggle that led to the signing of Magna Carta in 1215. It's a struggle between Crown and the elite. I say that because I'm not assuming that in England there's any democracy that exists and the masses have any rights. But there are principles enshrined in the signing of Magna Carta in England that begin to define the relationship between the Crown and commoner, between people and their representatives, between the representatives and the Crown. When those Englishmen come to the Caribbean, they bring with them that legal background, that baggage, that tradition. And the point I'm really making is that when we signed the Oyster Charter, what the Oyster Charter in effect does, it acknowledges the Crown, that is true, but it also acknowledges that these Englishmen who would come and settle in Barbados, that there were certain rights and privileges that they were going to enjoy, and that these rights and privileges were enshrined not now hereafter, not just as on a matter of English precedent, but now as a matter of Barbados law. You are in Barbados, but you now have a document that says that there's certain things that you have a right to. And one of the things that you are arguing at the point is that you have no right to be, as it were, to be controlled by a body in which you have no representation. So your people in Barbados, your members of the House Assembly, they're the ones who had the right, as far as they were concerned, to control things. That is not to say that there's not a Crown and a governor who wields tremendous power. Not saying that at all. We're not We're not suggesting that, but we're just saying that there are principles. There are principles of constitutionality which are bound up with the position of the Barbados Assembly at the time. And eventually, over the years, those principles become entrenched. So that, as I show you, when you have the Temporary Stamp Act, the British government is trying to impose the authority on the colonies in the Caribbean and North America. The Barbados Assembly makes it abundantly clear there are things that you're proposing in the Stamp Act that run contrary to our understanding of our rights and privileges. You move past that and you go to the 1870s. So from 1600s to the 1700s down to the 1870s, and your British government is trying to effect reform. But in attempting to effect reform, they're also attempting to change the structure of the local political establishment, and they lose. They lose because the Barbadian plantocracy is quite absolutely clear in its own minds as to again its court rights and privileges. And what it does, it effectively gets rid of the governor. It puts enough pressure on the governor. The problems in Barbados, the riots, the formerly enslaved people and descendants know very well that the governor really is in a fight against the planters, and they take the governor's side, but that didn't work. And from that point onward until you get to the 1940s, all that happens is that the assembly consolidates its hold on power in Barbados. It is, and any change that's going to take place is really going to take place largely through the assembly. It is true that we're not going to ignore the 1930s, the riots, the disturbances in Barbados. We're not saying that people do not fight for change, but essentially all the change that you see taking place, they're taking place within that political legal construct that we call the assembly, and its passing of law, etc. And then we move from that to independence, and again the same parliamentary independence and tradition continues. That's the link. And by the time you get to the Proclamation of a Republic, where does it take place? There's no referendum in Barbados. No, there's no war in Barbados. There's no military struggle in Barbados. You have a series of discussions, but ultimately the matter is settled where? In Parliament. And the matter is settled in Parliament because Parliament has acquired a certain legitimacy, which is based on historical legacy and precedent, which we can trace right back to, guess it, the Barbados Charter or the Oyster Charter. That's what I'm saying. Okay, stop there. Probably was going on a bit too long there. Yes.
That's okay. That's okay. Remember, persons can put their questions or comments in the chat and also on Facebook. We have Mary Hill Harris, who is thanking you for a very interesting and informative talk. Okay. Another question that we would wonder is, we spoke about the Confederation Rights and the 1930s period. Could you just elaborate a little bit about that to the public in terms of its importance to our Barbadian history? Although the changes happen in the Parliament and in the Assembly, and that's where the legal changes happen, what about the power of the people as well in effecting change?
Well, let's go back to 1876. And one must understand that as a proud descendant of Afro-Caribbean ancestors, I'm quite aware of the fact that our people over the centuries have been struggling for their rights and privileges themselves. So while I'm talking about a parliamentary tradition, I'm not ignorant of the fact that our people back from Basso Rebellion, before that, back as far as 1670s, Kofi's Rebellion, coming right down through, our people are struggling. But come 1876, it is clear that nothing had changed since emancipation. Absolutely nothing. The laws, the franchise was a restricted one. By and large, you had a population by that By 1870s, I think it's about 170,000, 170 arms, somewhere in there, along that. And if you counted among the masses, you would not find anybody who had managed to get in the assembly. There are a few people who were beginning to challenge the system. The Barbados national hero, Charles. No. I just stepping forward in time to another period. But I'm just trying to remember when the name slips me now. Barbados national hero who is buried in St. Mary's Church. I can see the tomb even as we speak. Who gets in the House Assembly? Anyhow, I'll come back to that. Hello?
Samuel Jackman, that's what you
Samuel
mean?
Jackman Prescott, yes. He is one of the few. And there are a few others who get in, but by and large, the masses have no access. That's the reality. A few persons who were of African descent become elevated in the socio-economic system, but by and large, the masses are left out. So when the Confederation Rights break out, well, the so-called Confederation Rights, I said the masses are clear that they have been deprived for over almost 100 years. Well, not quite 100. I'm thinking of a later period again. They've been deprived for centuries. They know that. And in fact, in the struggle to seek some improvement in the condition, their minds go back to the 1816 Bus Rebellion, and they refer to some of the leaders as generals, and they even refer to General Busser. So the masses are clear, but the fact remains that the struggle, the masses lacked at the time the necessary technical capacity to fight with British troops, to fight with the British forces, and the masses, and so you don't get much happening. There's no reform. There's no significant reform that takes place as a result of 1876. The only reform that takes place is in Parliament. Parliament succeeds in denying any change to concurrent government status. So Barbados is practically the only Caribbean colony that retains the old representative system intact. No change particularly. A few concessions are made in terms of the executive committee, executive council, but nothing of any major consequence. And you move past that period, 1876, and the Confederation Rights, into the 1920s, when a series of commissions come into the Caribbean and investigate conditions, and things are what we would say in today's parlance, dread for the masses. You have the First World War, things are extremely difficult, but there's some demand for sugar and some spin-off benefit from that in terms of employment after the First World War. But then by 1930s, you're into the Great Depression, and the masses who've been suffering for over 100 years plus after emancipation, or close to that, they again are seeking effective change. What they do is that, and there's some evidence that Clement Payne comes with a plan. There's some evidence that the agitation that we see in Barbados is not accidental, that there's we may call it a Marxist-Leninist background to Clement Payne coming to Barbados. And there's a purposeful attempt to shift the balance of power. And of course, we know what happened. The disturbances lead to some deaths. Some person are put in prison. Israel Lovell and others, some names that we know of. That is what is happening in Barbados. But what happens is that this takes place at a time when in Britain itself, there are some political changes taking place. the Labour Party has grown in stature. And there's a challenge, the British establishment is being challenged to pay attention to what's happening in its colonies. It's not that the British establishment is not racist. It's not that the British establishment is all that concerned about in the individuals, but there's a certain what we call imperial pride, and they begin to look at what's going on. You have the so-called Moyne Commission, which investigates things, but that's even before the change that took place in the 1940s. But coming out of the struggle, coming out of the struggle of the masses, it becomes clear that something has to be done. And hence, when you look at that struggling masses, when you link that with the rise of party politics, with the Barbados Labour Party, the trade union, the growth of the trade union movement, when we can say the masses played a significant role in the change that took place. But ultimately, the path towards social improvement is a path, is what I call the political legal path. And that political legal path is centered in the House of Assembly. That's where the legal framework is put in place that gives rights to people. The passing of legislation that allows for trade union recognition, etc. All that is a political legal approach that ultimately ends with the installation of trade unions, and also, of course, the entry into political leadership of Afro-Barbadians, led by Sir Grantly Adams and others. All this is tied together. So yes, the masses have a part to play. The masses do have a part. But again, I'm repeating, this is like a recurrent decimal. You're not going to find the changes that are taking place, and are changes that are taking place as a result of a revolutionary movement, challenging the status quo, and eventually forcing change. You know what's happening. These changes are largely put in place by the middle and upper classes of the political leadership. And once they effect those early changes, those changes take us step by step. You have mentioned federation or that thing, but all those issues, all the extra or the arguments or the actions outside of Parliament, you can look at those and you can find a lot of things happening. But ultimately, you trace the changes taking place, and those changes are taking place largely within that political legal tradition that we can trace back centuries.
Okay, that's it. And we have a question from Norma Springer. So in the forthcoming Republic Constitution, what improvements to the parliamentary system would you recommend? So she's asking, what improvements to the parliamentary system would you recommend?
Now, the truth about it is this, is that, as I said, we have a parliamentary system that, for all of its encrusted history, all of the racism that we can associate with it in the past, all of the issues that we can identify, social ills that we can identify, that has worked reasonably well. And that same parliamentary system is a system that has been used by successive Black governments to effect the changes. There are some persons who might argue that what we need in these situations, what they call revolutionary change. I don't know exactly what people mean when they say that, because when I look at governments in places like Cuba and other places, although there are revolutionary changes taking place in those countries, you look at the structure of their assemblies, basically the structure of their assemblies still bear a generic connection and relationship to the imperial colonial system that preceded them. What I would recommend is that there has to be a way with any constitutional changes, that any constitutional change, a way to what we may call to guarantee access of the masses to the citadels of power. We still have a fairly large divide between the parliament, the structure of what we call parliament and its traditions, and the people outside in the street. The people in the street tend to become only involved when it comes to largely around election time. But between elections, there's not normally a system that enables what we call a greater interface between people in their localities and Parliament and what happens there. So in a very real sense, a lot has not changed. And that is one of the areas that I would recommend that some change must come. There has to be some way of paying for it and change. Some people argue that we should go back to some kind of local government where in addition to the central government and Parliament, you have other systems put in place to effect a greater connection between the political system and the masses. But I think that the constitutional change, the constitutional changes could be put in place that would help the masses acquire a greater connection with the decision-making process, with what's happening on their behalf. It's not enough for a political party or parliamentary representatives to make a proclamation or pronouncement for the masses. This has to be able to get feedback. Find what the masses really want and let the masses have a place where they can demand what they want. That's as simple as I could put it. It's going to require a lot more thought than I've expressed here because it's a very complex issue. Yes.
This question may be a little similar to what you answered before, but you may add some other information to it. And this question comes from Facebook, from Amia Selassie Yacob. What was the impact of the resistance of African and African descended population to the development of the Barbados quote-unquote constitution?
I just laugh, but it's not a laugh. Any question is a very important question. There are many points of contact between what happens at the constitutional level and the action of the masses. As far back as we can go, changes have taken place within the Barbadian polity, the Barbadian political system. Change has taken place in the Barbadian political system in response to challenges from below. But not the challenges from below affected direct change. Is that those who are responsible for controlling the seat of power took into consideration this what we call the pressure coming from below, coming from the masses. And so you often had what we call cosmetic changes that took place. But in terms of a constitution, and let me come back to that question of constitution. When we talk constitution, the first major constitution that we have, the written constitution we have, apart from the Barbados Charter, come out again. Apart from that, coming on to the next big constitutional making exercise is in fact the independence or under the independence order, when Barbados acquires its constitution. That is the first thing you make, and there's no real sense that that any activity of the masses themselves had any major impact on that constitution. The constitution is largely the result of what we call of social engineering by the intelligentsia, by those persons who, the legal experts, the political experts. That's what it is. There's no sense that you have a major contribution by the masses, by the people into what the Constitution. This republic of which you're now a part has come about in a rather strange way. Again, I said mostly changes have taken place as a result of parliamentary edict, of parliamentary decisions. And now we've been told that there's going to be a new constitution, and that the new constitution will benefit from the input of a wide cross-section of the masses. That's what we've been told. But we don't have a new constitution. Not yet. We have a republic, but the constitution that governs the country is still essentially the constitution that we had before we had a republic. So I do not know, in answer to the question that has been put, whether the people, the masses themselves, will have what would be the nature of their imprint on the constitution whatever the constitutional development takes place. I don't know. Can't answer that question. It remains to be seen what's going to happen.
All right, we have another question. And this question is asking, if the Barbados Charter is so important, would you support a proposal for the event to be commemorated annually so as to inform Barbadians of our history? And this is coming from Reverend Buddy Laurier.
Let me say good evening to Reverend Laurier. The Barbados Charter is important. But as I said, it is important because it enshrines within its clauses certain principles, notwithstanding the legacy of enslavement and oppression that surrounds the sign of the charter. The charter does establish that certain principles, including the one that the people should not have certain restrictions on their freedoms, except with the consent of their representatives, the people. Those are principles laid down there. I'm not so sure that today's Afro-Barbadian public will be so happy with the commemoration of a Barbados Charter, which coincides with the passage of the 1661 slave law and all the other things that sought to dehumanize the existence of our forefathers. My own presentation is not intended to glorify the charter. It's not intended to glorify the charter but glorify the people who wrote the charter, who printed it, who put it out. It's really intended to draw to the attention of a discerning public that there's a certain, what we may call a certain historical legacy. There's a certain connection between the things that were being said, the rights and privileges that people were seeking to establish. There's a certain connection between that and the later developments that take place in the political system that lead us eventually to parliamentary, what I call parliamentary democracy, parliamentary anti-independence, and then finally to the time in which we're now living. There's that connection. I don't think we need to commemorate the Oyster Charter as such. I think Reverend Larry will be aware that I presented a lecture on the charter, just on the charter, around its anniversary, a few years ago. I think 2014 would have been the, yes, 2014, I think, can't remember what year, 1652 to 2014. You're younger than I am, Doctor. But I think it's 2014 that there was, in fact, a commemoration of the Oyster Charter. And so I suppose that in a local sense, I suppose the people in Christchurch, in Oysters, might, and the fact that the charter was signed at the Mermaid Tavern in Oysters, that they could develop some kind of commemoration. But the commemoration could also, I suppose, move forward in time by seeking to engage with those more positive developments that have taken place since the charter. So the charter, the charter will stand there as a kind of representative document that says, okay, this is what people wanted, this is what people intended to get out of promulgating this document. But as I see it, but moving past that, to show that the principles of rights and privileges and representative government that were put in place there have now widened and expanded, and we could celebrate that. It's awesome. Well,
Great. Thank you very much. Do we have any other questions or any comments? We have 2 more minutes for any discussion. If I don't see anything, I will just wrap up. So I'll just give you a minute to get your questions in. While we just give that last 2 minutes, Professor Welch, is there anything else you would like to reaffirm?
Oh Lord. All I would like to do really is to say to those, particularly those who are listening, I believe strongly in my African heritage. I am particularly concerned that we don't know enough in Barbados about our African past and some of the very positive things that our African forefathers bequeathed to us. Our lecture series, in which we're talking about the making of a republic, really is seeking to pull together a disparate set of historical facts, bring them together to show how the system has evolved over the years. I want to repeat: we didn't have a war, a revolutionary war, to achieve what we've got now. What we've got now is really the cumulative development of a series of political experiments over the years that have led us, each one building on the other, until we got to this place where we are now. We're following the same parliamentary tradition that our grandfathers knew and our great-grandfathers knew. We managed to put in place a legal system which we call a republic. We put that in place. And so I think that the two things have to go together. On the one hand, we have to understand that history. We have to understand the history, even some of it would be unpalatable. Even though we're talking about the history of our oppressors, even though we're talking about the history of a white establishment that sought to denigrate our existence, even though that is, we have to pay attention to that. And then, but then in addition to that, I am also saying that we also have to spend some time in tracing within our polities the contribution of our Afro-Barbadian forefathers, what they did, how they arrived here. A lot of people don't know much about the involvement of some of our Black Barbadians in the local government system, the Vichy system. That is not spoken about, generally speaking. Most people don't know about it. A lot of the later political development we see when Grant Adams comes into power in 1940s is preceded but a number of things are taking place. Our people are under oppression. It is sad that it took so long, but they're under oppression or not, our people were doing things. They were trying to work together to achieve the changes that they thought were important. We don't talk much about the Marcus Garvey and the UNIA groups that exist in Barbados. Dr. David Brown has done a tremendous amount of work on those UNIA groups in Barbados, but all that is part of the actual contribution to our evolution, and that has been spoken about too. So I would hope that at some point the museum and the university will get together to look at that other side of the political development that's taking place.
Okay, so we have our last comment here from Facebook. Amha has suggested that the slave laws and consequential laws were part of the quote unquote constitution. Would you agree? Or
I wish to refer to an article which I wrote in the Journal of the Barbados Museum and Historical Society, in which I have made available to the public a transcript of the 1661 slave law. The 1661 slave law and the slave laws that were passed were not as such part of the Constitution of Barbados, if we may argue that a constitution exists at all. The slave laws simply reflected a de facto situation in which the command of the island rests in the hands of enslavers. The constitutional issue is that the slave owners own the systems of control. That's where that lies. So that the slave laws are as I say it, simply an expression of that control that existed. So if you want to look for constitution, go back again, I say, to the 1652, the articles of the Barbados Charter. It is in that charter that what we call the rights and privileges are enshrined, that gives the same enslavers the right to do the thing that they wanted to do. But is that same constitutional background, if you call it that gives rise later in Barbados, that if you follow logically to the 1940s, that gives legitimacy, legal legitimacy, political legitimacy to the changes that took place when the masses for the first time were able to vote the representatives into power. That's not as a result of slave laws, that's more a result of what happened before that installed the system that we have. And that was the Barbados Charter.
Thank you so much, Professor Welch, for your discussion today. And thank you so much to the audience for your questions and your comments. You made the discussion engaging and stimulating.
Thank you. Have a good evening.
Just to wrap up, I just want to note that this year's lecture series entitled Road to the Republic, Exploring 400 Years of a Political Experiment, will continue over the coming weeks, presenting a comprehensive political and social history of Barbados covering over 400 years. Among several topics, as we heard today, the series will review other areas such as our early years as an independent nation, establishing sovereign relationships on the world stage, debating the whole idea of republicanism, and examining the final events leading up to the making of the world's newest republic. This year's featured lecturers include Sir Hilary Beckles, Dr. Christina Hines, Mr. Peter Wickham, the Honorable David Cummins-Shung, and Dr. Jeff Cumberbatch. Thank you for joining us for this first lecture, and I invite you to return next week at the same time on Wednesday at 3 p.m. Barbados time for the next presentation called Friends of All and Satellites of None,